Good day, Crime Talk aficionados. I hope you had a wonderful weekend. We have a great show for you today. First, there's an upcoming motions hearing in the Bryan Kohberger matter that will set the stage for trial. Karen Reed's defense falters as conspiracy claims struggle against mounting forensic evidence. That's right, a terrorist attack in Boulder, just up the street from the CrimeTalk studios. A quick Sean Combs trial update. And a mother shoots a convicted sex offender allegedly attempting to do terrible things to her daughter. We have This Day in Legal History, our quote of the day, and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that bell for notifications. And yes, you can check us out on any of your favorite podcasting apps. Now, before we get started, let me remind you, go to crimetalksearch.com where you can sign up for a background subscription service today. Now, when you have that background subscription service, guess what? You can do as many background searches on anyone here in the United States as your heart desires. And you can cancel at any time. So whether you want to do one or whether you want to be a online sleuth and check everybody out, you can do as whatever you desire. Now, when you do this, you're going to be able to get a report literally prepared as you wait. The report is then going to be emailed to you, and it's going to have all types of information as to the person that you're searching. For example, cell phone information that is related to them, emails associated with them, their social media presence. You're going to find out if they have a criminal history. You're going to find out if they're married, divorced. Are they on one of those public registries? Go to crimetalksearch.com, ladies and gentlemen. You're going to be happy that you did because, well, I'm telling you, we use this all the time here in the office, and you would be surprised. Something always comes up that surprises you. And sometimes, even if there's nothing there, well, at least you have peace of mind. All right, let's go ahead and open the record for Monday, June 2nd. Ladies and gentlemen, that's right, June 2nd, 2025. Can you believe already the start of June? Where has the year gone already? We haven't had, I think, maybe one clear day here in Colorado. It's been cold and windy and rainy, and I'm ready for some summer. Anyway, I digress. All right. First thing we want to talk about is the Bryan Kohberger matter. Now, we have a hearing coming up on June 18th of 2025, and that is going to deal with the motion to continue as well as the alternate suspect hearing. I told you last week, I don't think the judge is going to grant this motion to continue because he has already telegraphed at the last motions hearing saying, what have you been doing for the last 2.5 years? And on top of that, the judge will have the information that the defense wants for their alternate suspect motion. We did a show on what the law is. Basically, you have to be able to show that the real murderer is on the loose and you know exactly who it is and you can pin it to the point where basically a judge is going to say, let me go sign an arrest warrant for that individual because that is the real killer. Not aware of any of those affidavits being signed, and Bryan Kohberger still remains in custody. So I think that is some sort of preview as it relates to the validity of the alternate suspect evidence. Now, if you've been watching this show for a while, you know I have been a criminal defense attorney for 30 years. I'm always rooting for the defense. Our goal is to give it to you straightforward, all right? The facts, just like I have to tell clients, here are the facts to your case. Here's the good, the bad, and the ugly. And I can't ignore the bad just to make the client feel good because then you're walking into a storm, which could ultimately put somebody's jeopardy at risk. And it could be for a very, very long time. So you have to be intellectually honest, not only with yourself, but with your client as well. And let's face it, if the alternate suspect doesn't come through, the defense, although they never have to prove anything, is going to have a tough time to say that Bryan Kohberger is not associated with this case in some way. I know a lot of people say, well, you can't believe it, you can't prove it. But listen, the prosecution is going to be able to bring their witnesses in. They're going to establish that there are 4 dead people. And when they're cleaning up the crime scene, whoever was involved just happened to leave a K-bar sheath there, minus the knife, and guess what? Just happened to have Bryan Kohberger's DNA on it. To most jurors, that's going to be pretty compelling evidence, along with everything else about car similarities, things of that nature that we've talked about. No need to go through all of those again today. So June 18th, put it on your calendars. We'll bring you what we can bring you, but this is going to be what sets the stage. So first, I think we're going to trial in August, which is good. And second of all, I don't think there's going to be an alternate suspect theory presented at trial. Hey, let me know what you think. But if you're going to do that, other than saying, oh, I think Bryan Kohberger is innocent, they haven't proven it. Tell me what evidence, legal and competent evidence, you think the defense is going to be able to bring in at trial. Both legal and competent evidence, right, is relevant and admissible under the rules of evidence when you make your case. And guess what? We'll save the best one and we'll talk about it tomorrow as well. Next on the docket, Karen Read. Now. I said last week, if the state's case was so weak, why didn't Karen Read just rest their case and immediately go to closing arguments? I've said this. The last trial I did a couple weeks ago, 3-4 weeks ago, I guess now already. Guess it was last week in April. A week-long trial, almost a week and a half long trial. And guess what? How many defense witnesses did we call? 0. Rested. Why? Because the prosecution case was weak. If we had put on witnesses, it basically almost would have helped the prosecution prove their case. And what most people don't get, is that you don't have to prove yourself innocent. Karen Read thinks she has to prove herself innocent. Okay? No, it's about raising reasonable doubt. Okay? And we'll talk about it, but the witnesses today didn't exactly go as planned. And that's the problem. And that's oftentimes why the defense wins, is because things didn't go exactly the way the prosecution thought they were going to come out on the witness stand. And then the defense can pounce and you can create reasonable doubt. And maybe the prosecution doesn't have everything that they need to fix that particular witness statement. Kind of like what happened in Karen Read Trial 1. Now, Karen Read Trial 2, what do I keep saying? Better chance for the prosecution second time through, because they fix everything. They know what their theory of the case is. And now the prosecution knows the defense theory of the case. And the defense really can't deviate from that second time through. That's why, attorneys usually tell clients, don't make a statement. Why? Because you're locked into that statement. And if you change that statement, you will be impeached. And unless you can really say, gee, why I changed that version of the events, guess what? It's going to look like you're not being credible. All right? Particularly when it comes to the defendant, because everything comes in. So the Karen Read trial regarding the death of Boston police officer James O'Keefe, who was the then boyfriend of the defendant Karen Read. Now, obviously, Miss Read has pled not guilty, and prosecutors allege that Miss Read struck Mr. O'Keefe with her SUV and let him die in a snowstorm outside of 34 Fairview Road in Canton, Massachusetts, after a night of drinking. Like I said, Reed's pled not guilty to all the charges, which include second-degree murder, manslaughter while operating under the influence, and leaving the scene of an accident causing death. The defense contends that O'Keefe was beaten inside by fellow officers and then possibly bitten by the dog Chloe, and that Reed is obviously part of a huge cover-up and being framed by the police officers. Now, the first trial back in 2024 ended in that mistrial due to a hung jury, and the retrial continues. So on June 2nd, today, the defense began presenting its case after the prosecution rested. So far, 3 witnesses have testified. Jonathan Diamantis, a childhood friend of former Massachusetts State Trooper Michael Proctor, authenticated a text message chain in which Proctor made inappropriate and derogatory comments about Miss Reed, such as calling her a whack job and using offensive language, something that rhymes with punt. And he also, there's text messages reference Reed's medical condition and express some bias against her. And it underscores Proctor's unprofessional conduct and explains why he was fired after these messages surfaced after the first trial. Now, Diamandis confirmed the text, but noted he did not encourage or defend Proctor's comments. I understand why the defense wants this in, saying, oh, look, they're biased against her. Frankly, the messages aren't that bad. Basically saying, hey, this woman's a wackadoo. She, waffled this police officer was the term that was used in the text, i.e. running him over. And basically, had some derogatory things to think about her. Completely inappropriate, unprofessional. Indeed, he should have kept his comments to himself. It is what it is. And his friend was put in a very bad situation for having to authenticate this. I'm still baffled by the rules of evidence instruction that the judge allowed this in. How is this guy, this Diamantis guy, he can testify as to what he was testifying to by asking, what did you respond? What did you respond? But how is that not hearsay as it relates to Officer Proctor? Call Officer Proctor as a witness. The defense didn't. Now, the defense never has to do anything, but once they do, then, you can basically say, was that a good witness or not? I understand what they're trying to do. Look, he's a bad officer. He's going to get it. I don't think it had the impact that they were looking for. And then a former Canton police officer by the name of Kelly Deaver testified, and she's now with the Boston Police Department. She testified about her limited role back in January 29th of 2022 when she was on patrol, but then was called in to go work dispatch during an overtime shift. The defense had hoped that Deaver would support their theory of evidence tampering by recalling seeing ATF agent Bryan Higgins and former Canton Police Chief Kenneth Berkowitz with Reed's SUV in the police garage. However, Deaver clarified that her earlier statement to federal agents in August of 2023 wasn't an accurate memory, as her shift ended before the SUV arrived. She accused the defense of pressuring her to testify inaccurately, threatening her with perjury if she didn't testify as to what they expected, which obviously didn't do great things for the defense credibility. And then they started Dr. Marie Russell, an emergency physician and forensic pathologist, who's going to testify as it relates to the dog bites. They were just getting into the whole bite scene when they took their afternoon break. Anyway, she analyzed O'Keefe's arm wounds, suggesting they were consistent with dog bites rather than injuries from a vehicle collision. Russell, with experience in over 500 dog bite cases and at least 60 severe cases, explained that the dog bites often involve the front teeth, causing puncture wounds or skin defects. She also discussed her experience in wound pattern recognition, developed through her medical residency and work as an emergency room doctor and forensic pathologist. The prosecution had previously challenged her testimony, but the judge allowed her to testify as to dog bite wound recognition and basically let the jury decide what weight and credibility they give to the good doctor's testimony. Obviously, the defense strategy focuses on discrediting the prosecution's narrative by highlighting this investigative bias through Proctor's text, alleging police misconduct through Deaver's testimony, though quite unsuccessful, and proposing an alternate cause to O'Keefe's injury, Dr. Russell's testimony. Now, the judge also admitted some of Proctor's text messages into evidence after reviewing their authenticity while excluding others. All right, the intended purpose of that testimony was the defense called Deaver to bolster their theory of a police cover-up, specifically hoping she would confirm seeing Higgins and Berkowitz and with Reed's SUV in the police department's Sallyport garage back in January 2022, suggesting potential evidence tampering. But Deaver's August 2023 statement to federal agents indicated she saw those officers in the garage for a wildly long time, which the defense interpreted as suspicious. However, Deaver somewhat, I don't want to use the word retract or changed or modify the statement during her testimony, explained that her shift ended at 3:45 p.m. before the SUV arrived at the station. She described her earlier recollection as a false memory and stated she had no relevant observation, which obviously undermines the defense narrative. Now, the jury will have to decide what to believe. Obviously, she was impeached by her previous statement to the federal agents. And, the jury will have to give the weight and credibility to the officer. Now, the jury could say she's lying, she's covering up for the police, it's the thin blue line. Or they could say, she's trying to be helpful. She talks to the police a year and a half later. Okay, yeah, I think I remember it vaguely. I don't remember. But then, as more information has been provided to her since that time, she realizes that, it's kind of factually impossible because I wasn't even there at that point anymore. So, like I said, the jury will have to decide, but clearly not the effect or the impact that the defense wanted. At one moment, she said, my whole career depends on how I testify here today. The defense jumped up on redirect and basically tried to imply that her testimony here, how she testified, affected her work employment. I don't believe that's exactly what she meant at all. I think she said that as a police officer, my integrity as a police officer comes into play when I'm a police officer and I testify, and that therefore I'm not going to lie and I'm not going to say what I don't specifically recall, and I probably should never have made those statements, but she did, and she was impeached upon it. She was definitely not wanting to be there, and the jury will have to decide what to believe. Now, the one thing that really came across as bad is that on cross by Mr. Brennan, Ms. Deaver testified that the defense attorneys, particularly Alan Jackson, pressured her to align her testimony with their theory, actually threatening her with perjury if she didn't comply. Deaver emphasized her commitment to the truth. My entire job revolves around what I say on the stand right now. If I was to lie, I could lose my job. I lose everything. This portrayal of the defense as coercive likely, damaged their credibility with the jury. We'll have to wait and see. And like I said, then on cross-examination, Special Prosecutor Brennan clarified that Deaver's initial statement did not implicate ATF agent Higgins or Berkowitz, the former police chief, in any wrongdoing. And her retraction further neutralized any potential benefit to the defense. And Deaver's mention of a meeting with the Boston Police Commissioner, Michael Cox, where he encouraged her to tell the truth, did not substantiate claims of obstruction, as she confirmed no one has asked her to lie. Now, Deaver's testimony also revealed her limited connection to the case, as she was not interviewed about the observations until August of 2023 and had no direct involvement beyond her dispatch role. Her statement, quote, "I have no idea why I'm here. I have no connection to this case," end quote, likely reinforced the perception that the defense was grasping at straws. Her acknowledgement of knowing Sarah Levinson, a person present at 34 Fairview Road, was tangential and did not advance the defense's argument whatsoever. The defense attempt to salvage her testimony on redirect by asking if she was unbiased and referenced her initial statement failed to counteract the damage, as Deavers firmly stood by her previous testimony. And like I said, Hank Brennan capitalized on Deavers' testimony to reinforce her commitment to telling the truth and lack of involvement in any cover-up whatsoever. And Ms. Deaver denied any pressure from the Canton or Boston police departments, including from the commissioner himself, Michael Cox, with whom she said only encouraged her to tell the truth. Not a good start to where things are going. And the good doctor about the dog bite stuff, so far, not compelling. We'll see. Sometimes people look better on paper than they actually do testifying in person under oath. If you've ever had to testify under oath, it's a lot different. It's not easy for anybody to do that. And because you want to listen to the question and you want to make sure you answer the question and not add something to it. And you got to wait to see if there's going to be an objection. And it is much more difficult than most people think. But I think most people, don't get me wrong, it's not like it's some truth chair where somebody gets in there and they tell the truth. I've seen lots of people lie on the witness stand. But usually it comes out through cross-examination for the jury to decide who is telling the truth. Remember, cross-examination, the greatest truth-seeking tool that has ever been invented, for sure. But so far, the defense is off to a very slow start. Next, a terror attack just down the road from the CrimeTalk studios. That's right. Yesterday, Sunday, June 1st, a violent attack unfolded on the Pearl Street Mall in Boulder, Colorado, targeting a peaceful pro-Israel demonstration organized by the group Run for Their Lives. Now, the suspect, identified as Mohammed Sabri Solomon, a 45-year-old Egyptian national, allegedly used Molotov cocktails and, get this, a makeshift flamethrower to injure 8 people with injuries ranging from minor to quite critical. Now, the FBI is also in on the case, and they classified the incident as a targeted terror attack. And Solomon faces multiple felony charges, including 2 counts of attempted first-degree murder, despite because there's been no confirmation of any fatalities at this point. Now, of course, the Boulder Police Department said, even though the guy was saying this is for Palestine or words to that effect, they said, wait and see. We don't want to say that this is anything related to terrorism. or a crime of hate. No, they don't want to do that. Why? Because that's Boulder. Okay. It's Boulder. Okay. It's Boulder. Everything you ever heard about Boulder, probably true. Most beautiful place on earth, right? Great school, but the people, they embrace everybody. They're all peace-loving, hugging a few trees, eating some granola, you name it. But something bad happens in their backyard, they will be the first to throw you under the bus. I once had a trial up there. Jury deliberations took 5 days. 5 days on a case. The clerk said it looked like something out of a scene from A Beautiful Mind. They had like string going back and forth and dates and what have you. And if you do a jury trial up there, you will usually get at least, 3 to 5 PhD people because, well, all the professors live up there. It's a weird bunch. Everybody's tolerant until something takes place in Boulder. It's a very different crowd. Anyway, we're going to try to get up there ourselves and go check that out. It depends on how things go today. I have a court appearance. We had to get things done, but the goal was to try to get up there. We'll see. If not, we'll do it maybe sometime tomorrow. Anyway, this whole attack, sorry to digress, occurred about 1:30 yesterday afternoon during this demonstration to raise awareness for Israeli hostages held by Hamas in Gaza. Witnesses reported Solomon shouting, "Free Palestine," and Zionists and their killers while hurling incendiary devices at the crowd. 8 victims ages 52 to 88, including a Holocaust survivor and a University of Colorado professor, were hospitalized with burn injuries. At least 3 remain under treatment, with 1 in critical condition. Now, eyewitnesses described a chaotic scene with victims suffering severe burns and bystanders scrambling to get water to aid the injured. Now, investigators discovered at least 16 additional Molotov cocktails near the attack site, indicating obviously a little premeditation on behalf of Solomon, who sustained minor burns during the incident, was arrested at the scene and is being held on a $10 million bond. Now, the mugshot of Mr. Solomon shows a bandage over his right ear, suggesting that he may have been injured in the attack as well. But of course, it's Boulder. And of course, how long, they'll probably say the police were a little too rough on him. Oh, nope, there's video of them arresting him. Anyway, Solomon is scheduled to appear in court today at 1:30. He's not going anywhere. He'll be lucky if he doesn't get perhaps some sort of federal hate crime charges as well. We'll see how that plays out. Anyway, Solomon has been confirmed entered the United States on August 27th, 2022 via Los Angeles International Airport on a B1, B2 non-immigrant visa, which expired on February 2nd, 2023. He remained in the country illegally after overstaying his visa and then filed a claim with the U.S. Citizenship and Immigration Services on September 9th of 2022, possibly asking for asylum. And then on March 29th, 2023, Biden administration granted him a work authorization valid until March 28th, 2025, which he also overstayed that visa as well. Anyway, needless to say, the politics have already got into this case, and it has been confirmed that Mr. Solomon was not here in the country with a valid visa. And of course, all the reactions from the politicians and everybody else saying that they're shocked and this is no way to go on in life and people need to be nicer. Anyway, the FBI chimed in as well. The director, Kash Patel, and the deputy director, Dan Bongino, said they're investigating the attack as an act of ideologically motivated violence. I think that's called terrorism. And of course, our Attorney General, Phil Weiser, described it as a likely hate crime, given the targeting of a pro-Israeli group. Phil Weiser, nothing gets past you. And of course, the Boulder mayor condemned the appalling acts, expressing solidarity with the Jewish community and gratitude to the first responders. Of course, Governor Polis, who resides in Boulder, called the incident a heinous act of terror and pledged full cooperation with law enforcement. Anyway, it's even had a little chime in by Israeli Prime Minister Benjamin Netanyahu condemning the attack as anti-Semitic, urging U.S. authorities to prosecute Solomon fully and address rising global anti-Semitism. The University of Colorado issued a statement denouncing the violence and offering counseling services to those affected, noting that one of the victims was a university professor. Now, of course, like all things when there's politics involved, right, there's controversy over how the perpetrator was going to be portrayed. At one point, Mr. Solomon was described as a white male, despite his Egyptian nationality and his illegal status being confirmed by the FBI. Critics accused people of misrepresenting the facts. And, well, that's what happens on everything about that. But we're going to bring you the facts, ladies and gentlemen. And like I said, we're going to try to get up there. And as you can see from the video yesterday, there was still grass burning, and people were trying to treat people with severe burns. Anyway, but just coincidentally, the attack coincided with the eve of Shabbat, a significant Jewish holiday commemorating the giving of the Torah. Obviously, the timing heightened concerns about anti-Semitic violence, prompting New York Police Department to increase security at Jewish religious sites as well. And let's not forget, it was just last week, May 22nd, where 2 Israeli embassy staffers in Washington, D.C. were gunned down by a pro-Hamas individual. Anyway, the FBI also conducted a search of Solomon's residence in El Paso County, which is also known as Colorado Springs, as part of their investigations, and they're exploring Solomon's online presence and potential mental health issues, though no evidence suggests he was affiliated with a broader terrorist group at this time. The Boulder police are supposed to give a press conference right about the same time that Mr. Solomon goes to court, so we'll have a better idea as to what's going on. Just down the street, ladies and gentlemen, it can happen to anyone, anywhere. You got to be on the lookout. Indeed, be aware of your surroundings. Next on the docket, a quick Sean Combs update. The ongoing federal trial of Sean Diddy Combs in the U.S. District Court for the Southern District of New York, well, it's grabbing a lot of attention with allegations of racketeering, conspiracy, sex trafficking, and transportation to engage in prostitution. Doesn't want to know what's going on. Obviously, Combs, a hip-hop mogul and producer, has pled not guilty to all the charges that stem from that federal indictment that was handed down back in September of 2024. There were 2 superseding indictments, and this is the third week of trial as we begin the week of June 2nd. Now, the courtroom heard from the witness identified by the pseudonym Mia, a former personal assistant of Combs who worked closely with him for approximately 8 years, going as far back as in 2009. Now, Mia's testimony, described as harrowing and delivered in hushed tones, marked a significant moment in the trial as she became a second witness to accuse Combs of both physical and sexual assault. Her account provided a detailed and disturbing narrative of her experiences, reinforcing the prosecution's allegations of a pattern of abuse and coercion within Combs' inner circle. Now, Mia testified that over the course of her employment, Combs subjected her to multiple instances of physical and sexual assault. She alleged that Combs raped her, forced her to perform oral sex, and on one occasion repeatedly slammed a heavy door on her arm, causing her to believe that it was actually broken. These acts, she claims, were part of a broader pattern of control and intimidation, and Mia described Combs as an overwhelmingly powerful figure, stating, quote, "I couldn't tell him no about a sandwich. I couldn't tell him no about anything," end quote. Obviously highlighting the significant power imbalance in the relationship. She further noted that the interaction with police officers who appeared dazed or dazzled by Combs' celebrity status convinced her that reporting the abuse would be futile. In addition to her personal allegations, Mia corroborated earlier testimony regarding Combs' alleged abuse of former girlfriend Cassandra Cassie Ventura, and she testified that she witnessed or heard instances of violence against Ventura, aligning her account with that of other witnesses, such as Dawn Richards and Capricorn Clark. Now, Mia's observations that there was nobody around us that ever flinched at his behavior underscored the prosecution's argument that Combs operated within a network of enablers who who insulated him from any accountability whatsoever. The testimony was particularly significant in bolstering the racketeering charge, which requires evidence of a criminal enterprise involving multiple individuals and multiple crimes. Now, Combs' defense team sought to undermine Mia's credibility during cross-examination, and they questioned her about her social media posts and other public statements, attempting to cast doubt on the consistency of her allegations. The defense has consistently argued that while Combs may have engaged in domestic violence or drug use, these actions do not constitute the federal crime of sex trafficking or racketeering, and they attempted to portray Mia and other witnesses as potentially motivated by financial gain or personal vendettas, a strategy aimed at reframing the narrative from organized crime to personal disputes. It goes on and on, ladies and gentlemen. The more tawdry, the more interested people are. God, I wish it was videotaped so we could see the testimony, but it's federal court, so we don't get to see that. Hey, at least, I don't know how your weekend went, but at least you didn't happen to shoot anybody that was attempting to do terrible things to your daughter, like a woman in Indianapolis. So, a mother shot a convicted child molester after allegedly discovering him attempting to sexually assault her 12-year-old daughter in a hotel room, according to police reports. Now, the incident occurred on May 24th at the Baymont Inn on Eagle View Drive in Indianapolis, and the Indianapolis Metropolitan Police Department confirmed that the suspect, Bruce Pierce, sustained critical injuries in the shooting and, well, he remains hospitalized. Pierce is listed on the Marion County Sheriff's Office sex offender registry, classified as, wait for it, a sexually violent predator, since he was required to register back in 2019. So according to court records, it is alleged that the 12-year-old girl accompanied a family member to the hotel to locate her mother, who was with Mr. Pierce. The mother briefly left her daughter alone with Mr. Pierce in the hotel room while she carried items to her car. Upon returning to the hotel room, the mother allegedly found Pierce on top of her daughter, attempting to remove her clothing while holding a firearm. The mother reportedly shouted at Pierce to stop, drew her own legally carried firearm, and shot him. She and her daughter fled the hotel, but promptly contacted the police and returned to the scene to cooperate with police. That's the way you're supposed to do it, ladies and gentlemen. Shoot, call the police, let them know it was justified. Don't run. Don't try to hide. Makes you look guilty. Call the police. I was justified. Anyway, like I said, Pierce, a registered sex offender, was convicted of 2 child molestation charges back in 2016 and served prison sentences as well. His status as a sexually violent predator requires lifetime registration monitoring, and a court summary of his previous case indicates multiple charges against Pierce, including attempted rape, attempted child molestation, unlawful possession of a firearm by a serious violent felon. Now, as well as, let's not forget, a criminal confinement of a victim under the age of 14. Now, a warrant for Pierce's arrest has been issued, but he remains in critical condition at the hospital, which is delaying his arraignment. Anyway, the police are going to continue the investigation with detectives interviewing witnesses and reviewing the hotel surveillance footage. And the Marion County Prosecutor's Office is evaluating whether the mother, who has not been publicly identified, will face charges. But under Indiana's self-defense laws, it does permit the use of reasonable force to protect oneself or others from imminent harm, which may influence that decision not to bring charges. Anyway, the mother's firearm, just if you're wondering, was legally owned, and she is not a prohibited person. And she also has a valid concealed carry permit. No updates as it relates to any legal filings against mom. Boy, I bet that unidentified woman from Indianapolis wished she had CrimeTalk.com so that she could have gone and checked out Mr. Pierce to see that he was a sexually violent predator. Now, I'm sure Mr. Pierce is probably a fine individual, right? But I'm certainly not going to let him babysit my kids or be alone in a hotel room for sure. That's why you got to go to get CrimeTalkSearch.com, ladies and gentlemen. You never know who you're dealing with until you check them out. I'm hoping mom didn't know those facts, because if she did, well, not a good fact for her then. Next on the docket, let's talk about this day in legal history. June 2nd, 1692. Bridget Bishop was the first person tried for witchcraft in Salem, Massachusetts. She was convicted and hanged, marking the start of the infamous Salem witch trials, which obviously shaped early colonial legal proceedings and highlighted issues of judicial fairness. You know, she's a witch. Throw her in the water. If she floats, she's a witch. If she sinks, she's a witch. You can't go wrong. Next, on June 2nd, 1924, Congress passed the Indian Citizenship Act, granting citizens to Native Americans born in the U.S. Obviously, this milestone addressed tribal rights, and it fully did not resolve other sovereignty issues. And then on this date in 1930, federal agents conducted raids on illegal speakeasies in Chicago, targeting organized crime, exposed police corruption, and supported the repeal of prohibition. On this date in 1963, civil rights leaders were pursuing legal agreements in Birmingham, Alabama, following protests supporting desegregation and the Civil Rights Acts of 1964. And on this date, June 2nd, 1997, Timothy McVeigh was convicted of 15 counts of murder and conspiracy for the 1995 Oklahoma City bombing, reinforcing anti-terrorism laws like the 1996 Anti-Terrorism Act. And our quote of the day, since, in the Karen Reed trial, witness credibility is at issue. Let's have a quote regarding credibility. The credibility of a witness is to be determined by the jury, who are the sole judges of the weight to be given to the testimony. And they may consider the witness's demeanor, consistency, and any motives or biases that may influence their statements. So that case, that quote came from United States v. Smith, a Sixth Circuit case, but that is a general description of most jury instructions regarding witness credibility. And finally, our dumb criminal of the day. An Ohio man's DeWalt deception ends in a $4,000 heist at Home Depot. That's right. In a plot twist worthy of a hardware store heist flick, an Ohio man, Joshua T. Huey, allegedly masqueraded as a DeWalt sales rep to swipe over $4,200 in power tools at Home Depot. His grand exit, however, was less than a smooth operator and was caught red-handed. Now, according to the Austin Town Police report, an eagle-eyed Home Depot loss prevention employee spotted Huey slicing into sealed DeWalt toolboxes like a kid unwrapping Christmas presents. Armed with bolt cutters, conveniently borrowed from a nearby aisle, Huey allegedly snapped a lock on a metal gate guarding the good stuff, causing a bit of vandalism in his quest for cordless glory. He then played a game of hide and seek, stashing DeWalt batteries in a Home Depot bucket and a DeWalt bag as well. With the finesse of a bull in a china closet, though, Huey loaded a flatbed cart with 23 items, saws, blowers, grinders, and enough batteries to power a small village, totaling $4,200, and made a beeline for the exit without so much as a glance at the checkout. Spoiler alert. He didn't quite make it. Now cooling his heels in the county jail, Huey faces charges of felony theft, possessing criminal tools, and vandalism, with a court date set for Wednesday. Police impounded his Jeep and bagged evidence, including the bolt cutters, a broken lock, a knife, a book bag, a DeWalt tool bag stuffed with loot, and a clipboard with personal papers that probably won't help his case now, will it? Don't forget the surveillance footage, soon to be a detective's blockbuster, is expected to seal the deal. In the end, Huey's DeWalt dreams were cut short, proving that at Home Depot, the only thing sharper than the tools is the security. That's all we have for today, ladies and gentlemen. Sorry about the quick show. Have to run to court. Have a wonderful day. We'll see you next time. And remember, the Constitution matters.